you for being here. We appreciate it. My name is Marcia Morey. I am a representative from Durham, District 30, and I welcome you along with my colleagues and representatives, the other co-sponsors of this legislation, Deb Butler, Tim Longest, who's in a committee, and I'm sorry he's not here with us, and Phil Rubin. We are all lawyers, we are all Democratic members, and we have filed 3 constitutional amendments pertaining to ethics and our Supreme Court. We believe these amendments are critically needed and are meant to correct serious concerns that we have about the fair and impartial administration of justice in North Carolina. These amendments pertain to Supreme Court ethics, protection of separation of powers, and reforming the Judicial Standards Commission. I'm going to speak briefly, well, maybe not briefly, but about the bill I filed, House Bill 1236, which purpose is to de-weaponize the Judicial Standards Commission of North Carolina. I need to explain Judicial Standards Commission what it is. It oversees judicial ethics of our judges. The commission receives complaints from citizens, from lawyers, from anyone in the judicial system about judges who may be in violation of the code of conduct that judges must adhere to. It ensures that judges do not exhibit favoritism to former law partners when hearing cases, that judges don't delay in writing orders, that they have not recused themselves from cases where they have a personal or financial interest in the outcome. Our current laws pertaining to judicial standards was policy. It was not passed in a separate bill. It was part of a 625-page budget, which was passed in 2023. It was not subject to any amendments. And it was a dramatic policy change that inserted pure partisan politics in the Judicial Standards Commission. The Republican supermajority excluded lawyers and state bar appointees and put a supermajority of judges on the commission, a commission that oversees judges. The Republican Chief Justice and Republican leaders have 12 appointments out of the 14-member commission. The governor was given only 2 appointments. What's happened since that change in 2023? We have seen a weaponization of the commission, targeting Democrat Supreme Court justices with frivolous complaints. An anonymous complaint was filed against Justice Earls that attempted to sanction her about speaking out about racial bias in the administration of justice. The investigation was later dismissed when Justice Earls had to file her own lawsuit about freedom of speech. Then, in October 2024, 3 Republican state senators sent a letter that they publicized to Judicial Standards alleging that Justice Riggs should be sanctioned for speaking out about her support of reproductive freedom. Her Republican opponent immediately began running TV ads against Justice Riggs based on the senator's complaint. Only a cease and desist action from Justice Riggs stopped it. This kind of weaponization is a direct result of the General Assembly making all judicial races partisan in North Carolina. We want to return to a fair, impartial justice, free of bias and political warfare. My constitutional amendment balances the composition of Judicial Standards Commission. It puts 5 lawyers who are not judges back on the commission. These lawyers would be selected by the state bar. It keeps the Chief Justice with appointments. He would have 5 appointments, or she, all who must be judges from the Court of Appeals, Superior Court, and District Court. And the governor, who is elected by the citizens of the state, would get back his 5 appointments to Judicial Standards. This provides balance, that no one legal entity has a majority of appointments. The other main provision of my amendment is to provide more transparency about the judicial standards process if an investigation is approved. Currently, under our law, everything is confidential. There is no public record of charges, pleadings. My bill would change that. It would give more transparency. If a disciplinary proceeding is formally instituted after an investigation, all charges and filings would be made public. At least 8 members of the commission must vote to issue a public reprimand, censure, or suspension. Who makes decisions about discipline and who appoints decision makers are the most important questions in designing a fair and effective system of judicial discipline. This is consistent with the original 1971 version of Judicial Standards from the Courts Commission, which recommended judicial standards be composed of representatives of the bench, the bar, and the public. This is a constitutional amendment because it is necessary. We do not have continuous changes in the composition and the procedures of judicial standards. I will now turn it over to Representative Butler to talk about her constitutional amendment.
Thank you. All right. Well, thank you all for being here. You know, as a lawyer, I learned very early in my career a fundamental principle of legal ethics. It is not enough to avoid actual impropriety. You've got to also avoid the appearance of impropriety. The principle is taught in law schools, it is reinforced in courtrooms, and it is woven throughout our legal tradition. Because the justice system depends on what? Public confidence. A judge may sincerely believe that he or she can remain fair and impartial despite a financial interest, a close personal relationship, or a political connection. But the question cannot end there. The question must also be whether a reasonable member of the public can look at that situation and wonder whether those factors might influence the decision. Our courts possess neither the power of the purse nor the power of the sword. Their authority ultimately rests on the trust and the confidence of the people. When citizens begin to doubt the impartiality of the judiciary, the legitimacy of judicial decisions suffers. And let's face it, once public trust is lost, it is very difficult to rebuild. That is why my constitutional amendment is so very important. This bill is not directed at any one justice, any one case, any one political party. It is about establishing clear constitutional standards that will apply equally to every current and future member of the North Carolina Supreme Court. The amendment requires a justice to step aside when that justice has significant financial interest in a party or matter before the court. It requires recusal when close family relationships create circumstances that could reasonably call impartiality into question. It addresses situations in which a justice previously served as a legislator, all right, y'all take heed, and is being asked to rule on the constitutionality of legislation that he or she championed or was a primary sponsor of. The amendment also brings greater transparency to the court by requiring disclosure of substantial financial transactions, any income outside of your salary, and disclosure of sponsored travel. The people of North Carolina have a right to this information. They need to know about the financial relationships and circumstances that could create an actual conflict or an appearance of a conflict in the administration of justice. These are not radical ideas, folks. These are common sense. These are safeguards for us. In fact, many North Carolinians, I believe, think that this is already part of our constitutional fabric. So the purpose of this amendment is not to punish anybody, it's not to accuse, it's not to relitigate the past. It is to strengthen public confidence moving forward. When questions arise about whether a justice should participate in a case involving major political actors, close family relationships, significant financial interest, or matters in which the justice had direct involvement, the public should not have to rely solely on that judge's discretion. There should be clear, objective constitutional standards that protect both the court and the people it serves. For too long, discussions about judicial ethics have focused almost exclusively on actual wrongdoing. But that really misses the point. Public confidence is not undermined only when actual misdeeds occur. It is undermined when reasonable people believe that there could be that conflict. That's why the appearance, even, of impartiality is critical. That's why transparency matters, and that is why recusal, when necessary, matters. Justice is not only fair, it's got to be seen to be fair. This amendment is an opportunity to reaffirm a principle that should unite all of us, regardless of our ideology, and that is that transparency strengthens rather than weakens our institutions, and that the people deserve complete confidence in the integrity of their court. So, let's put it before the people. Let's see what they think about it. I think they would agree that this should be part of our Constitution. And so now it's my pleasure to introduce another of our colleagues, Representative Phil Rubin.
Thank you. And it is a real privilege to be here this morning because of how important all three of these bills are. My name is Phil Rubin. I represent House District 40 in Northwest Raleigh. You know, every middle school civics student learns a fundamental truth about our American system of government. They learn that it's built on checks and balances. Power is divided among three co-equal branches so that no single branch and no single group can dominate the others. It's a brilliant system designed to protect the rights of people by preventing the consolidation of power in one person or one party. But if you've watched this gerrymandered General Assembly over the last few years, you have seen those constitutional guardrails pushed to the breaking point, all in pursuit of total control, the very control that our system of government was designed to protect against. We've watched a really troubling and calculated pattern emerge in Raleigh. Time and again, you see legislative majorities using lame duck sessions and midnight votes to rewrite bills that bypass public involvement and seize authority that voters had just explicitly assigned to the executive branch, either by moving among Council of State members because the wrong person was elected to office, or simply taking the power for the legislature itself. We've also seen massive multi-page policy changes, everything from fundamental healthcare changes to major changes in the way we do campaign finance that are just shoved at the last second into unrelated conference reports with no committee hearings, no public notice, no public debate, no opportunity for the public to be involved at all. We've seen sweeping reorganizations of our state government stapled to so-called disaster relief bills. Legislators are forced to vote on massive rewrites of state law before the public even has a chance to read the bill. And at this point, it is utterly routine in the way the majority runs this General Assembly. As just a few examples, in 2023 with Senate Bill 20, we saw a safe surrender for infants bill turn into major abortion restrictions in a conference report, which was 46 pages long and somehow dropped the very same day the conference committee was appointed. Somehow. In 2024, we saw major campaign finance changes snuck into a conference report on a bill about masking and protests, and voted on the very same day with zero public involvement. And of course, we had Senate Bill 382 last year. Senate Bill 382 was an alleged disaster response bill, but when the conference report emerged, it rearranged executive powers among the governor, the Board of Elections, the auditor, the superintendent of public instruction, and the attorney general, sticking a finger in the eye of the public that had just elected those officers with the powers they had before that. And again, no opportunity for public involvement was provided. When you legislate in the shadows, you are intentionally excluding the people of North Carolina from their own government. And when you do that, who actually gets to write the laws? It's lobbyists. It is special interests. It is a few powerful people in this body and not the 170 people that were elected to represent the public. It is government by ambush, not government by and for the people, despite our state constitution's command that, quote, all political power is vested in and derived from the people. All government of right originates from the people, is founded on their will only, and is instituted solely for the good of the whole. Now, historically, the backstop against these abuses has been the courts. They're the referee when one branch oversteps its bounds. But the majority on our highest court has now chosen to look the other way with these power grabs. The Republican justices uniformly ruling in favor of a Republican legislature's changes in powers in our state government. And I'll return to Senate Bill 382. After a 3-judge panel, which is how we handle constitutional claims, found the transfer of the Board of Elections to the state auditor violated the North Carolina Constitution under settled precedent, the North Carolina Court of Appeals, controlled by Republicans, simply let the law take effect anyway, despite a court's ruling that it violated the state constitution. They did that without any briefing or argument or reasoning at all. And then it went to the state Supreme Court, which at least did issue some writing on it, but did not have full briefing, did not have oral argument, and again said, go ahead and go for it. We'll let this law take effect. They quite simply walked off the job when it comes to protecting separation of powers. The Constitution already says that executive power belongs to the governor, but when courts refuse to enforce that basic principle, the people of North Carolina need to correct them and make it unmistakable. And that is what brings me to House Bill 1235. We are introducing a constitutional amendment to restore sanity, transparency, and accountability to Raleigh. This bill does 3 vital things. First, it permanently secures separation of powers. It strictly prohibits the legislature from passing laws that impair the governor's constitutional duty to execute the law. Furthermore, it ends this partisan game we now have of musical chairs where the legislature plays around with the powers of the Council of State depending on who won the election. You can only change powers from a Council of State member before the election occurs, and it only takes effect afterwards. If you really think the auditor should be in charge of elections, you should make sure the people know that when they're voting for auditor. Now, I would tell you this is already constitutional law. Separation of powers is right up front near the very top of our Constitution. But since some folks have decided that that is optional, this amendment makes it emphatic in our Constitution. Second, it ends the era of gut and replace legislating. This amendment mandates that every single bill passed by this General Assembly must have one single subject. If a bill is about masking and protests, it cannot secretly become a bill about campaign finance later. If a conference committee is appointed to resolve a dispute between the House and the Senate, the only thing they may do is resolve the dispute between the House and the Senate. They may not add any other issues to the bill. And the third thing this bill does is it guarantees public notice and participation. Under this amendment, no bill may be voted on by either house without 24 hours of public notice. And the actual text of the bill must be made available to lawmakers and the public at least 48 hours before that vote occurs. No more of the practice that we do in this body where even members of the body are handed a bill mere hours before a vote is taken on it. Sometimes minutes, that's right. These are common sense solutions, and it is deeply disappointing that the majority controlling our legislature and our courts have fallen so far from these principles that correction is necessary. But it is, and so we filed this amendment, House Bill 1235. It's not lost on me that we're approaching the 250th anniversary of our nation, and it's time that we honored the principles that brought us this great country that has thrived. Other states across the nation, Pennsylvania, Louisiana, Florida, already have most of these protections I've described this morning. This isn't new, just like Representative Butler said. These principles are not new. It's time that North Carolina caught up. Our Constitution belongs to the people and not politicians, and the people of North Carolina are not an obstacle to be worked around in the legislative process. They are the primary party to be involved in it. We should give them the opportunity to secure their Constitution, demand absolute transparency in lawmaking, and ensure that people, not backroom deals, have the final say. Thank you. Thank you for listening and being here. We would be glad to take any questions you may have.
Good morning. Thank you guys for having this. Last year, we all know that the challenge by Judge Jefferson Griffin made a lot of headlines. Did that have anything to do with bringing this legislation forward this year? And then my second question, when we hear talk about the courts from Republicans, they often mention magistrates and some cleanup that they want to do there after several high-profile crimes. Are you guys also working with Republicans on stuff like that?
Yeah, do you mind if I start with the first part of that? Yeah? You know, I think it, for me, and you've heard a lot today about sort of issues with confidence in the judiciary, and so this goes to your question about the Jefferson Griffin challenge. That is another great example, right, of a partisan judiciary ruling in the way that would lead someone in the public to think these folks might be making these decisions on a partisan basis. And look, judges are going to go different ways in some cases, but what's really shocking about this, the North Carolina Supreme Court's ruling in the Griffin case, is a federal judge who was appointed by Donald Trump ultimately found that our Supreme Court violated the United States Constitution. And like, I want to say that again, just to make it clear. Our Supreme Court justices violated the Constitution of the United States and violated the constitutional rights of North Carolinians. That is shocking. And I got to tell you, for those of us lawyers up here, we all knew it was going to end on equal protection in federal court because it was the obvious answer to that question. And the fact that a partisan decision of the Supreme Court couldn't find the answer that I would expect a law student to find on this, it shakes my confidence in the courts. And so while none of these bills sort of goes to that specific thing, although if you look at House Bill 691, I did file a bill on that specific thing, I think it goes to our frustration and utter lack of confidence that the court is acting impartially at this point. And so that it certainly does inform. And I don't know if anyone else wants to jump in on the second question.
That was perfect.
Yeah. Can you remind me exactly what your second question was?
Yeah, last year specifically, we heard a lot from Republicans after the Arena Zarutska case in Charlotte. We just heard a lot about cleaning up magistrates and training in the courts and stuff like that. And oftentimes when we hear from Republicans about cleaning up the courts, they focus on that. Is that also something that you guys are working with Republicans on, or are these completely separate issues? I know they sound separate, but, you know, is there any work?
One thing that I think we see far too much of here is that terrible, horrific facts and events lead to very bad law. Knee-jerk reactions to things that shock the conscience of us all. Irina's law is an example, and we have Jalea's law coming right now, today probably, which was a terrible circumstance where a child was killed in concert with some gang activity. But what we have to do when these bad facts occur is pause, reflect, involve the public, involve the stakeholders, the experts, the people in the space who know it best, and institute reform where necessary, but not do something that is going to have unintended consequences like Irina's law. Our courts and our jails are going to explode. Let me say that again. Our courts and our jails are going to explode. I have already heard from many of the judges in my region that we are probably going to need to build at least one more jail. And I don't think that was an intended consequence of that law. So, again, bad facts make for knee-jerk bad law, and we need to slow down and do things more thoughtfully with involvement of the public.
Let me add, also, one provision in Irina's law was taking away the authority of the Chief District Court Judge, which I was in Durham for 18 years, and gave it to the Chief Justice, who could remove a magistrate at his own discretion. You know, what has happened back to our local control? We have seen time and time again stripping of local control and the Chief Justice assuming more powers over the Office of Administrative Courts, over magistrates, over appointments. And so in some ways it's related, but I think Representative Butler put it well in the other aspects of that law.
On judicial standards, I wonder if you all had seen the proposal from Justice Berger Jr., who wanted to amend the Code of Judicial Conduct and loosen the political speech rules. Do you have any thoughts on that?
Well, here we go again. You know, I think the mistake happened, and I wish Judge Joe John were here, who is a representative, also a former judge. Once we opened the can of worms, making every judicial race political, we have really made a mess of what can and can't be considered ethical when it comes to political speech and judicial races. You know, I think we have to adhere to our Code of Judicial Conduct. We have to be careful in our speech. You cannot talk about a case that may come in front of you during a campaign, but I think now that we have partisan labels, you can talk about your philosophy, you can talk about your freedoms, and so I think it's up to how the court sees the proposal of Justice Berger to open up political speech, but I think it will result in much more acrimonious contests, and it will take it out of justice into just campaign warfare. Yeah.
At this point, has there been any conversation with the Republican majority or unaffiliated in the House to talk about the support for this constitutional amendments?
They're hearing it today.
Yeah.
Yeah. We hope they'll sign on.
How likely is that?
None.
Well, let me say this.
One can hope.
Yeah, I will say this. It is my expectation that they will read it with open eyes, and if they view it through an apolitical lens, like we would hope they would do, I think they will embrace it. I mean, look, political offices come and go. Those who are elected come and go. And there's an awful lot of bad law that has been passed by the leaders we currently have that is really probably going to come back to haunt them. It's time for them to start correcting some of that before we get the reins, okay?
And just to add to that, I think that's one strength of all three of these bills, is that they set neutral rules. These are the rules that should be followed when Democrats have a majority on the state Supreme Court. These are the rules that a Democratic-controlled legislature, which is coming, will play by and should play by in this building when we are passing legislation, right? So none of this is written to give one party or the other an advantage. And I hope that, as Representative Butler said, that they will look at it neutrally and see that this is actually a way forward out of this sort of bad place that we're in. Because I actually, even when I talk to folks on the right in private, I don't think they feel like this is going that well. Like that there's actually a better way for all members to participate in the legislative process, for example, and that we could actually get to that place with neutral rules. And I would suggest that they should look at this with open eyes and open arms, because they won't always be in the majority. And when they're not, they're going to suddenly think these are great rules. So let's do them now.
Good job.
You talk about like the legislative process issues. How much of it do you think is driven by leadership, and how much of it is an institutional problem? I know the House had a leadership change recently. The Senate has a leadership change coming up. Is there any hope that that could change things if there's no, amendment to the Constitution?
I mean, I think there have been some procedural improvements in the House so far. I was not here under the prior speaker, but I understand certainly we have better notice about when things are going to happen, I think, is generally what I hear from people. But I also think that those kind of things, until they are embedded in law, suddenly fall by the wayside. We don't even follow existing statutes in the General Assembly right now that control our legislative process. For all the discussion about property taxes, it is against the law for this body to consider a bill that impacts the revenues of local governments without getting a fiscal note. Guess what? We never, ever do it. And I've asked why, and it's, hey, we don't have notice of even when things are going to be voted on. And so I don't have faith that it will last, is my point to your question. Different leaders will take different approaches, but it's going to be really hard to hold the line of, no, I can't insert this shady provision into the bill when technically you could. And so if the Constitution comes in and says, you can never do that, the law will be void if you do that, that actually empowers a future speaker or a future speaker pro tem to actually do the right thing, because they can say, hey, my hands are tied, we're not allowed to do it. So I do think changes in leadership could bring improvements even without a constitutional amendment, but I think the only way to guarantee that is to put it in the Constitution. Almost stole your pen.
And Kyle, that's a great question. We also could change it by our House rules.
Yeah.
The first day of session, we pass House rules. We have no input in that. Take it or leave it, these are the House rules. This is what a conference report is. There are no amendments. There's no time limits. There's no, requirement for the public to be heard. Look at yesterday. We had a bill come up that involved Government Operations Committee. There was an amendment no one saw until it was on the dashboard. We were reading the amendment when it was called for a vote. Suddenly the speaker says, without wasting a breath, call it for third reading, no objections, vote. Voice vote. I stood up and said, we changed the title of that bill. Our rules prohibit a third reading on the same day. Our rules mandate. He said, we all waived it. I mean, it went by in a flash.
You didn't object in time.
Yeah. That amendment is going to have profound implications on the uncontrollable authority and control of government ops over secret confidential investigations. We haven't even begun to realize how serious that was. And yet I stood up and said, that changed, aren't we supposed to?
No.
Nobody objected at the time. The time happened in less than a second. I mean, that's what we're facing. And I think that's what Representative Rubin is trying to address with his amendment.
And just one more thing on that, before we even got to that, you can't even change the title of a bill per the House rules, because an amendment, it's the only time you actually have to stick to the topic, is an amendment on the floor has to be germane. It has to be related to the title of the bill. It wasn't. He had to change the title of the bill to do this, which tells you it's not in the title. And when Representative Longus objected, they took a beat, they thought about it, and they came back and said, well, the bill is about government and and like the treasurer was a treasurer bill is part of the government, and the bill has some things about transparency, so it's germane. Okay, I mean, I thought rules were rules. I thought this was like a rules-based order, and so that again is why you need to constitutionalize these things, and they need to have teeth. So what this amendment would do is, if you violate the single subject rule, anything that's not in the subject is void. The legislature might pass it into law, but it ain't law. And so I think what we're learning in this era is that norms aren't enough. In the past, you could live with norms, right? You could say, hey, we're going to do this in the right way, in the fair way. That seems to be breaking down, and that is a shame. But the only response to it is to make rules that prohibit people from taking advantage of that. Any other questions?
All right.
Thank you so much. Thank you for being here.
Thanks, everybody.